All right, so now we're going to switch gears. No more family law. We're going to switch gears and focus on the immigration side, the UAC cases, and specifically here we're going to talk about the use of expert evidence in immigration matters. So again, my name is Dalia Castillo-Granados, and I'm the director of the ABA's Children Immigration Law Academy, or CILA. I wanted to remind you to, if you have to run out, please leave your CLE credit sheet with us if you want us to report your CLE, and also fill out those evaluations after every presentation. So we're excited to have with us today Dr. Zayas. He's the Dean of the UT Austin School of Law Social Work, and he traveled all the way from Austin to be with us today for our training. For this presentation, he's going to give us some tips on how to work with an expert from an expert's perspective. And he's also going to join Brandon Roche in the next presentation after lunch on child development and child interviewing techniques. Dr. Zayas was appointed the Dean of the UT School of Social Work in January of 2012. Before joining UT Austin, he was a professor of social work and a professor of psychiatry at Washington University in St. Louis. Born in Puerto Rico, Dr. Zayas attended college and graduate school in New York City. His social work career has spanned over 35 years, and he has worked in clinical practice, supervision, administration, and research. While extending his focus to research, teaching, and administration, Dr. Zayas has remained an active practitioner throughout. Presently, Dr. Zayas is focusing on the plight of citizen children whose parents are being deported. Through grant funding, he's examining the effects of deportation on the psychosocial functioning of U.S. citizen children of undocumented Mexican immigrants. As a practitioner, Dr. Zayas is involved in evaluating citizen children and testifying in immigration court on behalf of citizen children and their families. We would like to extend a sincere thank you to Dr. Zayas for joining us today and sharing some of his expertise with us. All right, so I'm going to start the presentation by going over some of the rules to consider when presenting expert evidence in immigration court and before U.S. Citizenship and Immigration Services. And then we're going to go through some practical considerations when introducing this type of evidence to bolster your client's immigration case. And then we're going to hear from Dr. Zayas on tips for working with an expert from an expert. All right. So, why is expert evidence even important? It's important because it can boost the credibility of the applicant, it can corroborate facts at issue in the case, and it can substantiate the applicant's claim. I worked on a case several years ago of a Cameroonian woman who was kidnapped. This was her asylum claim. She was kidnapped by a fawn, or a chieftain, in her father's village who claimed her as his wife. So her claim about how she narrowly escaped a forced marriage seemed incredible, and the immigration judge said so. But the immigration judge ended up granting her asylum claim due in large part to two country conditions experts that we were able to get to help corroborate her story. Immigration judges and officers are not going to be experts in every case that you bring before them, on every country condition or every claim that you have. So experts are really important to give that information to the judge. They can help the judge or adjudicator making the decision on the claim. And they can be used both in immigration court and before USCIS. They can also be used in any of the humanitarian grounds of immigration relief that immigration attorneys present on behalf of immigrant children's cases, but they're especially useful in asylum claims, and so that's what we're going to focus on in today's presentation. So the type of expert that can be useful in presenting your client's case is going to depend on the facts at issue in your case. A medical expert is going to be helpful when you're trying to show past physical harm. For example, if your client has scars or has suffered female genital mutilation, then it's going to be worthwhile for you to work with a medical expert that can attest to those facts. A mental health expert can be helpful to prove a mental health diagnosis or to show how trauma has affected the client. For example, if the client has suffered some severe trauma in their past, introducing a forensic psychological evaluation to show a diagnosis of PTSD is going to be really helpful in your case. And finally, a country conditions expert, which we see a lot of in asylum law, is going to be helpful to show the conditions of the client's home country, to show that the past or future harm is possible, and to help establish the nexus requirement. So let's start by looking at the standards of introducing evidence of any kind in immigration court. A respondent in immigration court has a statutory and due process right under the Fifth Amendment to a full and fair hearing and a reasonable opportunity to present evidence. You'll see here that I cited to INA 240, and you can look at that standard. In order to show a due process violation, the respondent is going to have to show that they were both denied a reasonable opportunity to present the evidence, and then also that it resulted in some sort of prejudice. The sole test for admission of evidence in immigration court is whether the evidence is probative and its admission is fundamentally fair. So we all know that the federal rules of evidence are not binding in immigration court, in immigration proceedings, and that the evidentiary considerations are more relaxed than in federal court. But the rules are helpful to provide some guidance in determining what evidence is going to be admissible. So the federal rules of evidence provide a helpful framework to help the immigration judge decide whether to admit the expert evidence, and if admitted, what probative value or weight to give that evidence. The first thing we have to look at is the admission of evidence. Federal Rule of Evidence 702 provides the standard for admission of expert evidence. It states here, if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. If the testimony is based upon sufficient facts or data, the testimony is a product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. There are three basic requirements for admission or exclusion of expert evidence under Rule 702. The relevance of the expert testimony, the qualifications of the expert witness, and the reliability of the expert opinion. First, let's look at relevance. The evidence is going to be relevant if it will assist the trier of fact to understand the evidence or to determine a fact in the issue. The regulations provide that the immigration judge may consider any oral or written statement that is material and relevant to any issue in the case. Second, the expert is qualified by knowledge, skill, experience, training, or education. If you look at the Immigration Court Practice Manual, an expert witness needs to include their CV or resume as part of the record of proceedings, and that's going to go to the expert's qualifications. What constitutes adequate qualifications is broadly defined, but the courts have generally deferred to the immigration judge's determination about whether an expert has the necessary expertise. Third, and the most significant issue, is going to be whether the expert evidence is reliable. In order to be reliable, the evidence should be based upon sufficient facts or data, should be the product of reliable principles and methods, and the principles and methods should have been reliably applied to the facts in the case. In this case, Daubert v. Merrill Dow Pharmaceuticals, which is the seminal case on expert witness testimony in federal court, the Supreme Court ruled that the trial judge should determine whether the evidence is reliable and relevant and therefore admissible. The court declared a four-part test to determine the validity of expert evidence, which dealt with scientific evidence. So not all four factors are going to apply to every expert, this is going to be especially to immigration proceedings. In immigration court, Daubert is used as a guiding principle, but the test is not going to be strictly applied. In most cases, if the immigration judge questions the reliability of the evidence, he or she will allow the respondent to introduce the evidence, but will give it less weight based on the issues related to its reliability. So knowing the underlying basis for the expert's opinion and the sources relied upon to reach it will be important to understanding the value of the evidence. So for example, if the expert's going to be relying on a lot of Wikipedia articles, then the immigration judge is not going to find that his testimony is reliable. There also needs to be a link between the facts or data that the expert has worked with and the conclusion the expert evidence is intended to support. So the expert's evidence needs to be based on the facts of the case in order to be given appropriate weight. So that's it for all the really technical stuff. Now we're going to talk about the types of expert evidence that is allowed in immigration court. Because immigration proceedings are an administrative adjudication, expert evidence can be in the form of live testimony, telephonic testimony, or written testimony. In order to admit live or telephonic testimony, certain procedural requirements must be met. So the witness list, including the expert's resume or CV, must comply with the filing deadlines given by the judge. And for telephonic testimony, a motion has to be filed explaining first why the witness cannot appear in person, and then also stating the telephone number and the location from which the witness will testify. You can also do telephonic testimony even if the person is abroad. If you're going to have an international call, then the respondent has to provide a prepaid telephone card for the immigration judge to use. And the decision, ultimately, whether to allow that telephonic testimony is going to be up to the discretion of the judge. So if that expert is not available to testify live or by telephone, written testimony from the expert is allowed. So most likely you're going to be submitting written testimony from the expert regardless of whether or not they're going to be available to give live or telephonic testimony. But here we're just talking about admitting or the submission of written testimony with no live or telephonic testimony. Because it's a due process violation to exclude any probative expert evidence, the immigration judge is most likely going to allow you to submit that written testimony. However, because both parties are entitled to a reasonable opportunity to cross-examine witnesses in immigration court, that submission is likely going to be given less weight. One more thing to remember with written testimony is that if it's general in nature and not prepared specifically for your case, then it will likely be given less weight. So it will affect the weight of the evidence and can be seen as another general country conditions report that you submit. All right, so before we get into the practical considerations when presenting expert evidence, I just wanted to touch quickly on introducing expert evidence before USCIS. So again, here we're going to focus specifically on asylum. You can submit expert evidence for other types of humanitarian-based cases, such as SIJ, VAWA, UT, and the evidentiary standard for all of those is any credible evidence. So you're given wide latitude to submit expert evidence in any of those cases. So before the asylum office, the officer can rely on other credible sources, including expert affidavits or evaluations. And according to the affirmative asylum procedures manual, there's no restriction to the amount or nature of documentation that the applicant is allowed to submit. Also, according to the regulations, the applicant can have witnesses at the asylum office. And according to the affirmative asylum procedures manual, the officer cannot refuse a witness the opportunity to testify, although they can place a reasonable limit to the length and subject matter of the statement. So this guidance is probably going to contemplate a fact witness, not an expert witness, but the distinction is not made. So I just wanted to point it out for you. You're most likely not going to want to present an expert witness at the asylum office, but here's the guidelines. So now that we've gone over all the rules, let's talk about some of the practical considerations when deciding whether or not to get an expert for your asylum case. Expert evidence that is relevant and reliable can be really useful in your asylum case. It can help the immigration judge or asylum officer understand the case better and hopefully help them make a positive determination in your case. However, we all know that the biggest hurdles are going to be time and resources, and that's especially going to be true for nonprofit attorneys working with indigent clients. In immigration court, a country conditions expert can be really helpful to meet the requirements for asylum eligibility. So it's recommended that you introduce a country conditions expert. Before the asylum office, you may want to forego the use of a country conditions expert, especially given the time constraints. Also, the asylum office has a dedicated research unit and a virtual library that all officers have access to. That's frequently updated with country conditions if you want to, trust the resources that they have. And a medical expert is going to be really helpful in your case if you're trying to prove past physical harm. So if you have something like I said earlier, like scars, or if they suffered female genital mutilation, then you should seriously consider having a medical expert. And of course, the mental health expert is going to be helpful if you're trying to show past psychological harm or a specific mental health diagnosis. One more thing that I wanted to say is that it's going to take some work to find an expert. And it's also very likely that the expert will require at least a nominal fee. So you're going to have to discuss this with your client before even starting the search. So some resources that hopefully will be useful to finding an expert are here. Her country conditions expert, CILA, is working on an expert bank with a list of potential experts to contact for some of the more common UAC claims. We're also working on getting some general declarations from experts on some of the more common claims. That will hopefully be useful, at least in your country condition documentation. Like I said before, if it's general in nature, then it's going to be given less weight than if it's specific to your client. Other resources that you can look to are other resource centers, such as CGRS, Clinic, ILRC. You can post a question on some of the more popular listservs to see if anybody's used an expert that they might be willing to share with you. You can contact your local bar association, like AILA has a chapter in every city, to see if they've used an expert that they like. You can also just look on the college website, see if they have, an anthropology or sociology or international studies department, and just stalk the professors and see who has done some research, for example, in Honduras or on a particular issue. Scholars and researchers the same. You can reach out to human rights groups to see if they have any experts, and you can also try to use journalists. I know a colleague, when I was working at Catholic Charities, had a trafficking case for a woman from China, and she had been a victim of trafficking in the 90s. I think she, had dealt with the snakeheads, and she actually reached out to a journalist who was able to provide a really great country conditions expertise that helped with that case, and she ended up getting a visa. So the impact on the case can be really, really tremendous. So for medical or mental health experts, you're gonna first want to find out whether your client's already seen a health professional that can maybe help with this type of evaluation. If not, you can work on getting a forensic evaluator to see the client. A forensic exam is different than the regular practice because it's for evaluation purposes only, and rather than for treatment. I always recommend people start with Decisions for Human Rights by completing the request form online. And if that organization is able to find a willing expert, then they'll notify you. So you should do this very early on in your case because it can take several weeks for them to find somebody that can help you. And then, of course, you can always try your local community health centers. For example, in Houston, through the Houston Immigration Collaborative, they did a pilot project where they worked with the local mental health agency, and that has worked out really well for clients. So once you've identified some potential experts, you're going to want to come up with a little case blurb of non-identifying case information that you can send out to several people. Whenever I looked for example, country conditions expert, I sent emails out to at least 5 or 6 different experts and see who return the email. If you're lucky, one of them will return the email. So some steps to working with an expert. A lot of this is going to be common sense, but I just wanted to write it out for you guys. Once you have identified an expert, you're going to want to obtain consent from your client to share their case information. I mean, obviously, you probably already talked about it, considering that there might be a fee, but maybe some written consent would be a best practice. You're going to want to set up a phone call or a meeting to discuss what information you want from the expert, so that they have a very clear understanding of what it is that you're looking for. And you should also be prepared to give the expert all of the relevant case information to help in their expert opinion. This is going to include your client's application and probably their declaration as well. Even if you're not submitting that declaration in court, it's always good to have one so that you can work with it and it's helpful for the expert as well. It's also probably a best practice to have the expert sign a confidentiality agreement. This is going to be more so for a country conditions expert, because if you have a medical or mental health expert, then they have their own confidentiality guidelines. But if it's a professor at a university, you might want to have them sign a confidentiality agreement. Of course, if it's a medical or mental health expert, you're going to want to set up a meeting between your client and the expert. If it's a country conditions expert, it's not always necessary to set up a meeting, but you should offer it to the expert just in case they want to talk to the client to determine credibility for themselves. In the case that I talked about earlier with the Cameroonian woman, she had several phone calls with both experts because they wanted to determine whether her story was credible. So once the expert has all of the relevant information, you're going to want to discuss a deadline for a final draft of the written testimony so that you have a chance to review it before you need to submit it. So you're absolutely allowed to give feedback. So you want to give, you want to let them know if you need to change, whatever, some of the facts in the case, or ask them to change anything in the affidavit. It's totally allowed. You can do that. And then after they have reviewed your comments and finalized the affidavit, make sure that you have an up-to-date CV or resume because you're going to want to submit that with the affidavit or evaluation when you submit it to the immigration court or the asylum office. And finally, if the expert's going to be testifying in immigration court, then you're going to want to prepare the witness. So you should prepare the expert witness by first explaining, this is just a best practice, but by first explaining some of the asylum and immigration court processes, especially if the expert's not familiar with the process. So you should go, and then second, you should go over the questions that you're going to ask on direct examination, and you should also go over potential questions that they might get on cross-examination. You should try to practice through a mock hearing if time allows, with someone acting as a judge and another person acting as a trial attorney, so they get just like you would with your client, so they get a real life feeling for what it's like testifying in court. And then you're also going to want to prepare the witness for questions from the judge. It's been my experience that most questions for experts come from the judge as opposed to the trial attorney. In immigration court, the first thing you want to do, of course, in any court, is lay the foundation for why the witness should be considered an expert. You can try to call the trial attorney before your hearing to see if they'd be willing to stipulate to having the witness qualified as an expert. If you don't ever get a phone call back or the trial attorney is not willing to stipulate, then you're going to have to voir dire the witness, which means that you're going to have to examine the background of the witness to assess qualifications or fitness to give testimony. And you can do this by using the witness's resume or something. You can try to start the hearing by maybe doing a resume and asking the court if they are willing to consider your witness an expert. Or you can just go through, in painful detail, all of the resume or CV. On direct examination, of course, The purpose is to elicit all of the relevant, on direct examination, you want to elicit all of the relevant information, and you're going to want to lay the foundation for how the witness came to their conclusion. By going over what sources he relied upon and how he applied those sources or resources to your particular case. You should try to keep the questioning simple, prevent the witness from narrating, and refresh the witness's recollection if necessary. And that's for any witness, not just us. The purpose of cross-examination is to question the reliability and credibility of the expert witness, so you're going to want to prepare you should be prepared to object if necessary, but focus also on redirect. So take lots of notes, make sure you redirect to rehabilitate the witness if necessary. Something that's common in immigration court proceedings is that the judge will offer to accept the written testimony for its full evidentiary value and will want to pressure the attorney to forego witness testimony. I've had it done to me many times. So you should beware of the practice if you think that the witness's reliability is going to be questioned on cross-examination. Because what will end up happening is the judge will credit all of those discrepancies on cross and not give you full full weight for the testimony that you would have brought up on direct. So if you think that there might be an issue, if you think that the trial attorney might become very aggressive or question your witness's reliability, then just go through the full testimony so you can preserve that record, especially if you're going to need to appeal later on. All right, that's it for my part of the presentation. And now we're going to turn it over to Dr. Zayas for an expert's perspective on tips to working with an expert.
Thank you very much and good morning. It's a pleasure to be here among attorneys who speak a different language than mental health experts do. I just want to point out that I'll be building on what Dalia has started. And my experience is built on the over a dozen cases in which I've been expert witness in cancellation of removal cases. I've supplied a declaration on what happens to children in detention for the RILR v. Johnson case, as well as the Flores v. Johnson case, indicating how children can be damaged by spending time in detention. Last summer, we were able to present some of this at a congressional briefing in Washington, D.C., and more recently in the case of grassroots leadership versus the Texas Department of Family and Protective Services, where the state was trying to say that Carnes and Dalia, the two detention centers in South Texas, could be licensed as child care facilities. So I'm working on that basis. A lot of what I'll talk about is included in the book that was published last year, Forgotten Citizen. This is primarily for U.S. citizen children whose parents have been deported and they've been affected. In it, I have an appendix in which it covers some of the material that we'll talk about today with respect to the use of the expert witness. Let's see if I got this right. Yes, I'm going to have to. Okay, so what I wanted to talk about was, I'm sorry, I can't see my own slides either. So I can speak loudly enough, and I have expert witnesses. My 3 kids say I talk too loud anyways. So anyways, so I wanted to talk about which of the mental health experts you really want to choose, select. It can be a psychologist, it can be a psychiatrist, a nurse, a licensed clinical social worker, psychiatric nurse in this case, who have expertise in working with families and children in particular. Sometimes, as attorneys, you may think of the case as the child or the spouse or whoever the parent. As a psychologist and social worker, we think of the case as the family. They're very tied together. And again, as Dalia mentioned, we need to know what are the characteristics of the case. What do you want to present on behalf of your case, your client? When do you need an evaluation? And Do you really need an evaluator or just an expert witness? Someone who can tell you about in general, what happens to children versus someone who will evaluate that child and give you specific information. So the expert should, as Dalia mentioned, have the knowledge, skill, experience, training, and education. The other is that the facts must be linked. The data must be linked in order to present the case that the expert witness should be able to present. As I teach my students, facts before inferences. We need to collect all the facts, then pull them together. You don't draw inferences as an expert witness on something that you didn't mention before. It has to be strictly on the facts. And for those of a certain age, you'll remember just the facts, ma'am, from Dragnet. The young ones won't remember it. Well, you won't remember because you hadn't seen the show. Anyway, so I want to build on the steps to working with expert witnesses. Again, the attorney makes a request to the expert witness. And in this case, I've done these evaluation of a dependent, in my case, citizen child, or more recently, in evaluating the children who are with their mothers in the detention centers in South Texas. And as an expert witness and someone prepared to work with you, I've got to recognize that it's a high level of responsibility. So the person that you select should really take this very seriously. Not that they won't, but it's really important that, we're talking about people's lives at stake here. Avoiding the dual relationships. I don't have any family that's attorneys, but I would, we have to keep those relationships very clear. I ask the attorney, what do you want to achieve with this evaluation? It's not an IQ test. You're not asking me to evaluate the child's intelligence. Chances are you're asking me to tell you about what would happen if this child was removed or their parent was removed, or how are they doing in detention. In the case of children in detention, we're seldom asked why, what happened in Honduras or Guatemala, right? It's what's happening to them now. And I think it's important that the expert have clarity as to what you're looking for. And then we have to think about any ethical challenges that I, as a mental health expert, might face. In one case, where I testified in a case in Florida, and that was a telephonic case, I learned later, I didn't ask enough questions, and I learned later that the father who was being deported had multiple misdemeanors and criminal cases. And so after that, I said, no, never again. Now I ask the questions up front. Who am I really representing? Is this someone I want to keep here in this country, or someone who's endangering the lives of our community? The basics of the evaluation, again, we go back to the clarity of the purpose of the evaluation from the attorneys, and then collecting background information. That's where it's very helpful if you've already got information from your pediatrician, the school, any other legal documents, if the child's been in foster care or anything like that. That helps me begin to know the child. Some people would say, I don't want to read those because it might bias me. But I already want to know in advance what we know about this child. Because if we have records of say, foster care placement, we'll know how they've adjusted to changes in their lives, to new places in which they live. Excuse me, could I pass me my bottle of water? Thank you very much. It will help me begin to establish how I'm going to go about my evaluation. I often use developmental scales, whether it's self-concept scales. Typically, I like to start, and I would urge you to tell your experts to start with some drawings. And actually, I'm going to show you in a couple of minutes some drawings that were elicited by the attorney, not even by the mental health experts, that were incredibly helpful to us. So the important thing is, to ask the child to go ahead and, spend some time drawing. But we may ask, as part of the evaluation, to have some drawings, primarily to see if, for example, the perceptual motor integration is adequate. I'll use the Bender-Gestalt motor test. I'll ask, the younger kids will do more drawings. Teenagers are not going to draw for you. They're going to be able to speak to you more and tell you. And then, of course, the evaluation request, I'll skip the country expertise. But the issue of scientific reports, I've also learned over the years that if I can cite empirical literature published in reputable, peer-reviewed scientific journals, I can be more persuasive. And I may even document that in the evaluation that I write or in the cover letter that I send the attorney. So I might add that, such and such 2014, found that in Mexico City, this is the number of pediatricians who can provide mental health, and this child, if returned to Mexico, would suffer these. So that sort of thing, and you can say that if in the most populous city in this hemisphere, there's not enough mental health care for this child, chances are they're going to suffer if they go to even a smaller town. And then, of course, there's the court testimony. This is a child that was, in this case, this is a drawing of a little boy from, I think it was Honduras, and he was talking about the Rebos Locos. He was asked by his attorney, "Well, I interview your mom. Why don't you just draw something for me, and draw something about what it was like back in Honduras when you were there." And this is what he talked about. That the Rebos Locos, these gang members, smoked cigarettes and carried firearms. And then here they are, more of them with firearms, and they're shooting at people, they're burning houses, and there's even a dead person over here. This very same child had seen his uncle gunned down, and I remember him telling me that he saw his uncle's teeth in the back of his head when he was shot in the face. Here's that same boy at the funeral of his uncle, and you can see the parents and the family members were crying. Everyone's crying. The cemetery, even the son was crying. There were nice trees in the area, but this was elicited by one of you, an attorney, who said, "While I interview your mom, you go ahead and show me, draw pictures of what your life was like back home." It could have been bucolic, but it wasn't. He was coming from a very dangerous place. This was very helpful to us in presenting testimony, well, actually for the attorney in the asylum case, the asylum hearing, to present to the court. So, of course, as Dalia mentioned, you set up the appointment and the interview. You make sure that the expert and you understand what the purpose of that meeting is, and of course your client understand why you're speaking to a psychologist, a consejero, a trabajador social, whatever you're going to call that person, a shrink, if you like. But the importance is that everyone's clear about what you're doing there. And as I mentioned, I'm not there to do an IQ test. I'm not trying to establish the child's intelligence. I'm trying to really produce a picture of the child's emotional state. Again, background. I will take a background information on the family, where they were from, what the birth order was, when the parents married or got together, how many, if there's been serial relationships, which child belongs to which father, that sort of thing, and a developmental history, what age. And most mothers will tell you pretty much about what age the child took his first steps, said mama or dada or whatever the first, and you get a sense of the child. You'll want your expert to know, were there any major illnesses that we should know about that might have affected the child, either with respect to physical ambulation and movement, using his extremities, or if there was some terrible fever or something that occurred that might have done some brain damage that might not be evident just by looking at the child. Again, if you have pediatric records, school records, and other reports, that's very helpful. In the cancellation of removal cases, the child has been in the U.S. since birth. So they've been attending a U.S. school and typically speak only English. So you've got a better record than you do when you're going into one of the detention centers to evaluate a child, because they've fled. They don't have necessarily the level of school records and documentation that we do in this country. They certainly don't have as much special ed and evaluations. So you're limited there. But with the removal cases, you can address those with the material that you can get from pediatricians and so on. I like to get any available information from the attorneys. How did the person come to you, and under what condition? Were they reluctant to come to you to have representation? And was it the family that urged? Who's paying for this? Sometimes they pass the hat and the family's helping out, or sometimes the person is struggling. Now, I may be different from some of the experts you talk to. I don't charge. I do pro bono. I do, if I have to travel, I will ask for lodging, meals, and drinks. But otherwise, it's really pro bono work that I do, and it's also very compelling to a case, because the government attorney can't say, Dr. Zayas, how much of your income is derived from testifying in court? None. Then they really don't have much to challenge my credibility on. And then, of course, I say your clinical observations. This is the mental health practitioner's clinical observations of the child. So you're getting empirical data through the exams that you're conducting, but you're also watching the child, how the child relates to you, and so on. When I write the evaluation report, I think about it as a very professional document that I want you, the attorney, to look your very best, and also for me to look good, so you'll hire me again. But to really be able to convince the court that the mental health expert that you've got is someone who, literally dots the I's and crosses the T. I'm even concerned with typos in the evaluation, because a judge could say, well, that was pretty sloppy, or the government attorney could challenge me. The typical, I have here sections of the evaluation. Again, it's a background, family, developmental history. Did I go over this already? I'm sorry, maybe it's the duplicate slide. And okay, it's a clinical observation. Will there be exceptional and extremely unusual hardship? That's really the question that I'll be dealing with in, again, the removal cases, and even the cases in asylum hearings where the child is expected to go back, or if they're deporting the parent and the child must return. Here's a copy of one that of a report that I anonymized, I guess, or disguised, where we have a child, a date of birth, when, at what age I evaluated the child. In this case, it was 6 years, 8 months. This is over 7 years old. Who the examiner was, in this case, me, and when I did the evaluation. And then I'm more specific, the dates and the sources of the information. I saw the child on the 10th, 11th, and 27th of September. I did direct examination of the boy, Christopher. I met his mother, his dad on each date. They completed the child behavior checklist. You might want to note that. It's one of the best measures of child's behaviors that we have. It's used a lot for research purposes, but it can also be used for clinical. And it gives you several scales, but most importantly, it gives you what is called an externalizing scale of disorders, meaning acting out, rule breaking, violence, that sort of thing. And then there's an internalizing scale, depression, vegetative signs, withdrawal, those sorts of things. And you really get some good data. And we use it. It's probably one of the most oft used measures in child psychology and child development research. In this case, I applied the child depression inventory to Christopher. There may be others. And by the way, here you have to make sure that your expert witness is qualified to use these instruments. Some instruments, like these two, can be used by social workers and licensed clinical nurses, but they may not. But then there are others that are more clinical in nature that require a certain level of expertise, licensure, and so on. So you might want to, I think the expert will know that herself or himself, and so it won't be a problem, but I think it's important so that you don't walk into court and get a surprise and say, doesn't this test require a PhD in psychology and 3 years of experience and on-site training, and your expert says, oh, but I didn't do those. It could be problematic for you. And then I speak to the reason for the evaluation. What did you want me to do? And in this case, he was referred by Mr. Smith, the attorney, to assess the child's psychological status and the potential effects for his mother's possible removal by ICE to Mexico, the effect that it would have on Christopher. And then I go some background about the child. He's 8 years, 8 months old at that point, the date on the evaluation. And I talk about parentage and that sort of thing. Then I describe the interview with the child. Now I'm just presenting the facts, okay? I have not yet drawn any inferences. So prior to the first visit, in this case, Christopher was a child with ADHD and was on medication. So I asked the parents to not, it was on a Saturday morning that I saw him. I said, don't give him his, I think it was Ritalin or Adderall, one of the two. I said, bring him to me, without the medication. And I got a sense of what these parents had to deal with. And in my office, it was difficult to contain him. He paced around the room very actively, tried to calm himself because he was in pain, but just couldn't. He really just couldn't. On the second visit, I said to the parents, bring him in medicated. And it was a different child altogether. Now, what was interesting about this case is that this boy would have returned, well, not returned because he was never there. He would have gone to live in his parents' Colonia village, barrio, somewhere in a small town in Mexico, where he would not have had access. It would have been a 2-hour drive to the state capital and about 6 hours to Mexico City for him to be able to get these prescriptions filled and get this kind of supervision he needed for his medication. So there was a lot of compelling information that I could work on with. But I described the interview and my observations of Christopher. And then I talked about the results of my exams. So here are the test results off medication and on medication when I did the Bender Gestalt, which it's an interesting perceptual motor protocol that you use. I use it often to break the ice with children because they like to trace and draw, and then you can get them to, you got to stay within the lines, and kids enjoy that. It breaks the ice, but I'm also getting a sense, is what this child's perceiving really being processed correctly? So can they draw, for example, a triangle the way I draw it, or the way it's drawn in the exam? And so I talked here about how he did on those with or without medication, the child depression inventory, and the CBCL. And then after I presented all of the facts, the report should really now pull these together. Right now, I've got all the facts. Now I'm about to draw the inferences, and this is what you'll want your expert to do. So I described him here as a neuropsychologically intact young boy who appears at stated age, average intelligence, but he's plagued by this pernicious form of attention deficit because of what I had seen in the first interview without medication. And I could call it was really bad. I mean, my office was a mess after he finished with it. And without additional specialized testing, the possibility, there was some problem with his speech, but I couldn't quite tell if there was a receptive or expressive language problem that would have needed more. Again, something that would not be available to him in the small town that he would have gone to in Mexico. So I made some recommendations. I don't always make recommendations, but since we kind of thought this case was going to be one, I went ahead and made recommendations so that perhaps the family and the court could ensure that he got intelligence testing, more educational testing to make sure that he gets assigned to classrooms where there's optimal care, and whether it's one-on-one or a class of same children who will need special help. And then I began to leave. He was now about 8 years old, approaching 9, and I predicted that pretty soon he's going to be approaching puberty, right? Which will place him at additional risk, primarily because with puberty and the hormonal changes, the cognitive and social development will change, will accelerate very rapidly. But children with ADHD often have difficulty during that time because the ADHD really ramps up. And without medication, they tend to seek self-medicating ways, whether it's alcohol, marijuana, other drugs. And then they tend to hang out with other kids that like them, because the kids who don't have ADHD are going to shun them because it's just too disruptive. So they'll tend, especially the boys, will tend to hang out with boys like them. And that spells trouble. And so I wanted to show that we're looking at a boy who would be going to Mexico at a time in his life when there's a great deal of danger. And in summary, then I provide the summary, and I give what I thought was important. It was in this case that I also found a paper that had been published about the lack of availability of services in Mexico City. So I extrapolated. If you can, and it was published by actually colleagues of mine at the University of California, Davis, where they found that there was a huge need in Mexico City for children, pediatric mental health, and there was just an insufficient supply of practitioners. So if you extrapolate that from Mexico City to a small town in one of the states that he would have been going to, we know that he would have been worse off. But I put that in the cover letter to the attorney. I think Dalia covered some of this, rehearsing the questions. Even after rehearsal, I would put my foot in my mouth a couple of times in court, and it it was helped by the attorneys to back off and get the foot out of the mouth. Because one point I used legal language, and they said, "Have you been?" And I shouldn't have done that. I should have stayed. I try to talk to my students and those who I've trained on this about how they present themselves in court. And I think we can jump down here to the bottom. The mental health practitioner really needs to be confident, clear-spoken, non-jargon. I think I see the role of us as explaining and educating the court on this child and on kind of these sorts of children and these sorts of cases in general. It's an educational process that I try to undertake. So therefore, I'm very careful now, more than ever, about how I will present myself in the case, in the courtroom. And of course, your government attorney is going to try to destroy my credibility. You all know that, right? So I have to stand firm that no, I've done this and I've got this experience and I know more about child psychology than they do. And I'll conclude. I think I can conclude. I see each case as a chance to protect the child against harm, whether it's remaining in a detention facility or being removed, as I call it in my book, exiled to another country because their parents have been deported, or orphaned because their parents are deported and the child is left behind in the care of someone that might be family or non-family. And again, each case is a chance to inform and instruct the court about something on child development and child psychology. I tell my students and colleagues that it's a chance each time to sharpen my skills and for you to train your mental health experts more and more with every case. The debrief is so great afterwards when the attorneys help me understand what I did right and what I did wrong. Because then next time I make fewer mistakes, or better mistakes, if you will, because at least I don't repeat the silly ones. And each case is distinct and requires a very different approach. And with that, well, the rest of these are just cases, but I'll stop there, take questions or discussion.
Does anybody have any questions? I'm going to repeat them for the recording.
So my question is, do you ever get, I know we've had this with experts where on cross-examination, the trial attorney always says, did you communicate with the attorney about this case? Yes, I did. On that issue of how much you communicated, what information you got from the attorney, one time the trial attorney and the judge was almost going to say, yes, this was a requirement that the trial attorney asked for a work product from the expert. This is a psychological expert, and didn't get it because we argued. But I wonder how often you encounter that they're always trying to, because you want a lot of information beforehand before you do your evaluation. And as you said, some people don't want anything, or they just want a general kind of thing. And so I was wondering whether in court you came across that.
Yes, I have, and it's necessary to communicate with the attorney. I need to know something about the case. However, what I do try to make clear is that the product that's before you, the written product, is mine. It's not in any way influenced by my relationship with the attorney and the request. There have been cases, in the cases that I have there, most of them, there was a disorder, an attention deficit, or in one case, selective mutism. But I had to present a case to the attorneys of a really well-adjusted teenage boy. And I told the attorneys, I don't know what's going to happen to us. But we're going to present this case of this 16-year-old boy who's just terrific. I mean, any of us would have wanted him to be our son. But what I did in the testimony was to pay tribute to his father, a single father. I said, this boy is terrific. And it's a tribute to the way he's been raised by a single father, and I talked about that relationship. So, while we had to communicate, I couldn't make up anything on this child, but I could then approach it from the perspective of why this father should remain in the United States. Sorry, I don't know if that answers the entire question. Yes.
So a follow-up question, do you include in your report all of the documents that you've reviewed, and does the judge ever ask you for the documents you've reviewed to prepare the report?
No, those are usually the attorney holds, and at least in my experiences, they're always already in whatever it is that you submit to the court in advance. And incidentally, I will not include the pictures or the drawings. I will analyze them in the report. I don't give those to the court.
Can you think of any particular questions you've been asked on the stand that surprised you from the opposing attorney, or that you weren't prepped for by the attorney on your side?
Gosh, there's so many. One time he just said, well, how many kids in a given classroom are on Ritalin? I really didn't know. So it was one of those moments where I said, I don't know. Because a teacher would know how many boys or girls in her class are on some kind of medication. But with respect to the population of the U.S. of children in schools, I couldn't tell. So those are some of them where they will tell you. I think the best thing is, I don't know. That's not information I have.
I think I saw that lunch is here. So we're going to break for about, yay. We're going to break for about an hour. Yeah, we're going to break for about an hour. You come out here to the stairs, sit out here in the lobby, or come back to your seats. And make sure you mingle and meet somebody new. Don't just sit with your colleagues. Meet somebody else from another organization.
We're going to start back at 1 o'clock. It says on the agenda 1:15. We're going to try to start back at 1 since we're a little bit ahead anyways, so we can keep the day rolling. Thank you.
No, no, you're right.
Okay. Yeah, I'll plug that in.
Thank you.